Hello everyone, I am Dr. Mohammed Afzal, and today I am going to discuss free consent as one of the essential element of a valid contract. Now, before discussing the term free consent as a whole, first of all, we must have to understand that what is consent. So, the legal definition of the term consent is given under Section 13 of the Indian Contract Act. Indian Contract Act under Section 13 mention that two or more persons are said to be consented when they are agreed upon the same thing and in the same sense. So, through this definition, which is given under Section 13, we can say that consent is nothing but it is the identity of mind. It is the consensus of mind which is necessary between the offerer and the offeree before entering into the contract. Now, we will discuss what is free consent as a whole. So, my dear friend, the term free consent is defined under Section 14 of the Indian Contract Act. Section 14 clearly mentioned that for getting the consent of the other party, it is necessary that his or her consent should not be caused by coercion, undue influence, misrepresentation, fraud, and mistake. The meaning is that if you want to enter into the contract and you are getting the consent of the other party into the contract either by using coercion or either you have used undue influence for getting the consent of the other party or either you have misrepresent him or either you have using fraud or you have using mistake for getting the consent of the other party into the contract, your contract is not enforceable before the court of law. The legal status of your contract is voidable. Voidable means voidable, it is a contract which is enforceable before the court of law at the option of one party but unenforceable before the court of law at the option of another party, right? So now we will discuss these terms which you obviously should not use. If you are using coercion, if you are using misrepresentation, if you are using undue influence, your contract cannot be validated before the court of law. So before entering into the contract, you must show that the consent of the other parties should not be obtained by any of the technique which is given under section 14. Now we will discuss these terms which are given under section 14, that is coercion, undue influence, misrepresentation, fraud and mistake in brief. Now first of all, we will discuss the coercion. What is coercion? So my dear friend, coercion is basically a physical threat. So section 15 of the Indian Contract Act clearly define the term coercion as coercion is committing or threatening to commit any act which is forbidden by the Indian Penal Code. Now the question is rises where the position of undue influence is exist. So the position of undue influence can be exist in a situation where one of the contracting party holds a clear and the apparent authority over the other. For example, in a relationship of the master and the servant, there may be the possibility of undue influence. In a relation of like doctor and the patient, there is a possibility of the undue influence because a doctor can influence their patient unduly. For example, in a relationship of police officer and the accused, there may be the possibility of the undue influence. And misrepresentation is defined under Section 18. Section 18 clearly mentioned that what is misrepresentation. But before getting an idea what is misrepresentation, it is necessary that we must have to understand that what is representation. Representation is something which is a statement of the facts made by the one party to another either before the contract or at the time of the contract for the purpose of getting the consent of the other party into the contract. That is representation. What is misrepresentation? Section 18 clearly mentioned that any representation which is wrongly made, either deliberately or unintentionally, it is termed as misrepresentation. And any contract which came into existence due to the misrepresentation of one party to the other for getting his consent, the contract is simply becomes voidable. And again, voidable means a contract which is enforceable before the court of law at the option of one party, but unenforceable before the court of law at the option of the parties whose consent is obtained by using misrepresentation. Right? And that party, that innocent party whose consent is obtained either by using physical threat or either by using undue influence or either by using misrepresentation, is totally free to file a case and challenge the validity of the contract before the court of law on the ground of misrepresentation, on the ground of undue influence, or either on the ground of coercion. Then we have the fraud. So fraud is defined under section 17 of the Indian Contract Act, and fraud is something like it is a deliberate act to deceive the other, or it is an intentional act to commit a fraud against the other. So if you have made a promise without any intention to perform it, it is treated as a fraud. If you are, for example, hiding any material facts to the other with the other party to whom you want to enter into the contract, it is also comes under the category of fraud. So any contract where the consent of the other party is obtained by using fraud is treated as a voidable. There is no validity, there is no enforceability of the contract if you are obtaining the consent of the other party by using the fraud. Then we have mistake. So this mistake is divided into two categories: mistake of law and mistake of fact. Mistake of law is further divided into two categories: mistake of the law of their own country and mistake of foreign law. So mistake of law of their own country means it is generally presumed from every individual that he or she should have proper knowledge of the rules and the regulations which are applicable in his or her country, because maximum of ignorance is of no excuse. If you are committing a mistake and mistake is related with the rules and the regulations which are applicable in your country, you are not allowed to take the advantage of your ignorance. Your agreement is simply void. It is not valid, not enforceable before the court of law. Then we have the mistake of the law of the foreign country. So mistake of the law of the foreign country is stand on the same footing as of mistake of fact. So if you are committing a mistake and this mistake is related to the violation of the law of the foreign country, your contract is simply becomes void. Void means your contract is not valid, not exist before the court of law. It is not binding between the offerer and the offering. Void contract means your contract does not have an existence even in the eye of law, right? Then the another category is the mistake of fact. So mistake of fact is further divided into two categories: the bilateral mistake and the unilateral mistake. Bilateral mistake means where both the contracting parties misunderstood the terms and the condition of the contract. It means both the contracting parties mistaken the terms and the condition of the contract and not have the identity and the consensus of mind. There is a confusion in the mind of both the parties related to the terms and the condition of the contract. Therefore, these kind of the agreements cannot become a contract, cannot be enforceable before the court of law if both the contracting parties not able to understand the terms and the condition of the contract, or either if both the contracting parties misunderstood the contract, or they can having the understanding of the contract wrongly, right? Then we have the unilateral mistake. So unilateral mistake means only one of the contracting parties mistaken. Only one of the contracting parties not understand the terms and the condition of the agreement. Only one of the contracting parties is not able to have the full knowledge of the various terms and the condition of the contract. It means only one of the contracting parties misunderstood the terms and the condition of the contract. Therefore, in that situation, if the consent of that party who is mistaken the contract is not obtained by using fraud, by using misrepresentation, or by using any kind of the physical threat, the contract is perfectly valid before the court of law. So, my dear friend, that is all about the free consent, and my submission is that while entering into the contract, it is the responsibility of both the parties that they should not use any of the term which is given under section 14 for getting the consent of the other party. If they are using any of the technique for obtaining the consent of the other party into the contract, then your contract is simply voidable. It cannot be enforceable before the court of law. Thank you.